4, 3.
Good afternoon. I'm Carol Dixon. I'm with the Idaho Federation of Families for Children's Mental Health, and I want to welcome you to our April parent webinar. Today we are talking about juvenile justice system and what to do if your kids or if you find your child has gotten involved in the juvenile justice system. And what we've done is kind of this new format that we have found to be really very successful and informative is that we have DeeDee Phillips, who is with Valley County Probation, and Ruth York, who is a parent who has experience in the juvenile justice system. So they're going to provide information and really do it in a way or in a manner, hopefully, that it kind of, a lot of questions will be asked to be able to clarify what does that look like, what does that feel like when you're a parent, and your family is involved in the juvenile justice system, so you kind of get some broad understanding of kind of how it works, how you should be prepared, what to do if things don't work like you think they should, and things that will be valuable, hopefully, as you go forward. So with that, I'm going to let DeeDee give a little information kind of why she's here, how this is kind of her passion, because to be participating at this level as far as kind of family engagement, I know I've worked with DeeDee for a couple of years, and it really is an area that's important to her. And Ruth just has a lot of rich experience that she's going to draw on, and also those kind of some other friends that haven't been involved and are knowledgeable kind of as their experience through the juvenile justice system. So with that, thanks for joining us. And DeeDee, I will let you kind of share some of your information, and then Ruth, if you want to jump in also.
That's great.
Thank you, Carol. Thank you all for joining us today. This idea and this information it's funny, but the family engaging into the juvenile justice system, even though you think it would have been around for a long time, it really is new and innovative in how to participate families and have them have a voice, a purposeful voice. So today I'm going to kind of go over just the kind of skeleton of the court system and where parents can engage, kind of what some of the wording and practices is in the juvenile court system, and hopefully give at least an introductory idea of where you can engage. Your questions are going to be really important because there's so many directions to go with family engagement and juvenile justice because they're your kids. They're your kids, your families. And I know that probation wants to do the best they can to serve our population to the best of their need of the family as well as that juvenile. I've been around for about 16 years and worked with a lot of high-risk cases. Started in Ada County and have recently moved to Valley County, so I have some experience with both big areas as well as the small rural areas. So hopefully I can be beneficial and answer some of the questions you have.
And I'm Ruth York, and I have children who are 18 and 21 now, and they are adopted. One of those kids spent a good bit of time between about age 13 and age 18 involved in the juvenile justice system. Some of that time was actually over in the state of Wyoming, which offers me a little bit of comparison experience to the state of Idaho. And my interest is just in helping parents to find their way through these stressful times that we don't envision becoming part of our lives, and how do we guide ourselves and our kids through these challenges and take advantage of the services that are available.
All right, so let's get started. I don't believe there is a single family or person out there that is hopeful to have their juvenile in our juvenile justice system, but if you do find your juvenile coming through our system, I'm going to give you a quick little background history of how we even got here in the first place. The Juvenile Corrections Act of 1995 was the first step in separating out juvenile corrections from the health and welfare system. So it's not that old. There we go. Trying to get it to move.
Trying to keep our audience up with our slides.
We're just on the next slide, if it'll go. There we go.
There you go.
And primarily legislation kind of dictates how probation, kind of guidelines of how we do our job, and it's for the entire state. And it's evolving. It's still, even this year, they're going to have some changes. And in that legislation is the balanced approach to juvenile justice, and that is how we look at offering, it's still,
Sorry, we switched our slide, but we're not able to switch
Worked really
your
well when we
slide.
started. There you go. Thank
Okay.
you. So whenever probation is making any sort of recommendations to the courts, it's based on this balanced approach where we look at the system as a whole. We look at the victim as well as the community, as well as the offender and what is best needed. You will see that if your juvenile ever gets to a sentencing. You also look at restorative justice, how to give back to the community if the juvenile did cause harm to the community. We look at all of those things together. So the first contact with the juvenile justice system typically starts with law enforcement. And that law enforcement can be just in the community or a school resource officer. And it's always important to remember that your juvenile has rights. The juveniles actually have more rights or different rights than that of adults. Whenever you come into court for the very first time, you will be given that list of rights. Some parents cruise over that and just sign it. I'm going to always encourage both the juvenile and the parent read that together to truly understand what rights the juvenile has.
I think that's a really good point because I know as a parent coming into the system for the first time, receiving various information from various places, I do remember going over those rights at a certain point with my child, but we were receiving so much information at once that really I wished I had taken a more almost studious approach from the start of maybe creating a file to put in all the things we were getting so that at different times, perhaps when I was not as stressed out, I could refer to some of the resources and really get a stronger understanding of the system than I ended up having during the time we were in it.
Yeah, it's very, very important. Even at this onset with law enforcement, the juvenile does have that same right to remain silent. What seems to get confusing is does a parent need to be present at that questioning? The law enforcement that I've spoke to, all of them, as I understand, have that practice where they try to contact the juvenile and the juvenile's parent before they talk with them. But if one is not available, they can have an advocate sit in with them, and that could be a teacher, a principal, family member, somebody, as long as there's another adult to sit with them while they're being questioned. If there's any concerns with that, though, law enforcement can't really question the juvenile without someone available. So at this time, no action can be taken or action can be taken, and I'll dissect kind of where that can go. A lot of law enforcement, especially in the junior highs I have found, will sometimes do behavior contracts. Let's say a juvenile is caught with tobacco or an infraction, or maybe there was a fight, but there's some things that they can work with within the school. They may hold that police report and not push it through the system. They can do that. They have that right to do that. If you're meeting with the officer at that time, you are welcome to ask, hey, is it possible that we can work something within the school, and see if they're open to that idea. It is absolutely up to the school or that law enforcement officer how they want to proceed, but you can surely advocate for your juvenile at that time and see if that's something that works out for them.
I think showing your parental interest and your family support can make a big difference to the law enforcement system in realizing that perhaps home can be a part of the solution, and potentially in the early stages of your child's involvement, giving them more leeway.
No, it's a very good idea. I know for a lot of us, having a parent engaged, even though they're frustrated and even though they may be scared by the system, to still be present and engage does help sometimes what that next decision may be. Because I think the world just wants to know, especially the juvenile justice system, is the juvenile going to be able to self-correct with the supports around them, or do they need further supports?
And I know that there's some real evidence in the literature. Studies have been done that are showing that key factors in the successful outcomes of kids who've been in the juvenile justice system, family involvement comes up number one in many studies. So I think sometimes we feel like it's our kid who's having the issue and we just need the justice system to fix them and bring them back to us. And what I learned along the way, and it was a little hard for me at times, was to understand that when a kid is down this road, that really it's taken a little bit of the whole family to get them there. So there's something not working in the family dynamic frequently that if you can tweak and show the justice system that you want to be involved in tweaking your family dynamic and helping your child to make stronger choices, then that leads to more positive outcomes typically. And I have found that judges and other staff within juvenile justice really are very responsive to a family that is showing the willingness to make some changes and do some learnings themselves.
Oh, agreed, because truly we're only in your family's life for a very short period of time, and then we're out. We don't offer saving, we don't offer fixing, we just offer guidance to what works hopefully within your family to make it stronger, as well as maybe offer resources and referrals that can help support you where you are and where you're wanting your juvenile to go. So yes, make sure my slides match up. Yep. So let's look at the no action taken. Kind of talk to you a bit about the law enforcement and their decision and what they can do. Then action taken, law enforcement may take a report and route to a prosecuting attorney. The prosecuting attorney, their office, who actually decides if there is enough evidence to move forward with the case. And once it gets in their hands, there's nothing anyone can do because it's going to be their decision. So if you're wanting to be in touch with the prosecutor's office once that report is moved forward, you can. I don't know that they're going to get back to you because once it's in their hands, there is a process now being laid out. And typically they cannot talk with the family until after an admit deny or a pretrial, because if you have an attorney, then they have to go through that way. Same thing with the adult system. You cannot be in contact with the prosecuting attorney's office until that first time in court and they decide or see what you're going to do. Now sometimes in the juvenile justice system, they may entertain that conversation, but it's rare. So that's the next step. If for any reason prosecution or law enforcement feel that the crime that's being committed puts the community at risk or the juvenile at risk, they can detain and take him into custody. And they can do that without parents' permission. There will be contact to parent, letting them know they're going to be arrested, or maybe you'll know that during that questioning. But if like a fight happens at school and it's pretty violent, law enforcement may just take that juvenile and take them to detention, and then you'll hear about it after the fact. I know it's frustrating, but for the safety of the youth as well as their community that they're in, whether it be school or regular community, they can take them into custody.
I think one of the hardest pieces of being a parent in situations like this is we know our child in ways that juvenile justice, that probation officers, resource officers, that law enforcement do not know our child. And sometimes, our mama and papa bear instincts want to come out. And I have found that the most successful tool I can use for keeping myself calm and creating the types of relationships that really do benefit both myself and my child over time is to just remember to assume that there really is positive intent by all the players in the system. Everybody has their own view into things, their own filters on things. Nobody's going to see your son or daughter from the filters that you do. And just trust that your time is coming to be able to share that information. But it's very stressful, and sometimes you really you want to go to this negative place in your head, and sometimes in dealing with the system. And my recommendation is to just look for ways that you can remain as calm and positive as possible, because you will literally get your day in court, and you will be heard from. And when you're heard from at the time that they're wanting to hear from you, that's when I think you are in fact heard the best.
And you'll see throughout, as we go through kind of the skeleton of what's going on with the court and what's next, where your voice is best suited and heard. So hopefully, I know Ruth will help me remember where to share that, because I truly believe a parent's voice is necessary and valuable throughout this process, even if you're frustrated or if you don't know which questions to ask or anything. To ask, to speak up so that you are best able to support your juvenile as they go through this, because it can get mucky, and we forget as juvenile probation for sure where a parent may be, especially at the beginning of the process. As you go through, we listen more, hear you more, and so does the court. So feel that that's going to be your priority, is to be able to teach us who your juvenile is outside of this crime.
And we want to make sure to share some information throughout this in terms of if your child has a mental health issue that you feel is complicating what's happening. Of course, that's important to share and to be acknowledged by all the players. And so we'll speak more to that as we go.
And I think you can ask questions as we go too, and Carol will let us know what those questions are and hopefully answer them to the best of our abilities. So the next slide just kind of shows once it's in the prosecutor's hands. The prosecutor can choose diversion. In all counties, diversion practice can be different. Sometimes that's pre-petition. Pre-petition is that formal document that states your juvenile has been accused of. That's what a petition is. And they can do that prior to that written petition. The importance of that is that once that petition is written, that begins the court record. And so some jurisdictions don't want that court record, and so that the case can just be dismissed and then it shows no court record on your juvenile. But that's up to the prosecutor. They can do diversion. They can summons the juvenile and the family to court. What that looks like is a marshal's going to come to your home, knock on your door, and give you that petition that reads what your juvenile's been accused of and give you a court date. That court date is the first court date, and I'll talk to you more about what that is here in a moment.
Can you back up 1 second? Just explain diversion a little bit for families.
So diversion is kind of, I'm going to call it a behavior agreement, because it's not a court order. It keeps the whole case out of court, again, so there's no court record. Usually either a juvenile probation officer meets with the family, goes over an agreement with that same balanced approach, how the family and the juvenile are going to work to make right whatever the crime was. Usually it's the juvenile with the parent support. The parent is very much involved in that agreement, because I think it's very important for you to bring to the table some of the early frustrations you've been having with your juvenile, that maybe you can get the court's support to remind the juvenile that, hey, if this gets any worse, mom and dad have this, or grandparents have this. You need to do as they say, and then you don't come back to our system. But if you end up do that agreement, whatever that agreement may encompass, then once they complete that agreement successfully, then that case is just dismissed. Any questions or clarifying?
I think that's good.
Okay. So the summons, and I kind of went over the warrant. Sometimes that summons, the prosecution may read that police report and feel that the risk is too high, and then can just do a warrant for the juvenile's arrest, and typically an SRO, law enforcement, and sometimes the probation department will contact the family and state the juvenile has a warrant and have them brought in.
The SRO being the school resource officer.
Yes, thank you.
Yeah.
I do want to the distinction between the civil court, downtown court, or magistrate court versus juvenile court. Usually tobacco and minor consumptions of alcohol tickets that I think most of us under, that goes actually to civil court. Juvenile courts don't have any jurisdiction over that. That's actually under the Juvenile Corrections Act that they separate those out. Things that will be petitioned, not cited or ticketed, are things like the petty theft, the possession of controlled substances, most of the misdemeanors, that kind of stuff. And so those will end up going through juvenile court. DUIs, for example, are traffic offenses. Those still go through civil court and not through the juvenile probation system. So if they come in on detention, the first court date is like an arraignment for an adult, and they will be, the parent is present. This is one opportunity that the judge may ask you, kind of if you have anything to say, and what supports we can put in place. They'll go over the charging information and just explain what your juvenile's been accused of and see if you have any questions. They're not going to ask if they did it or not did it. If they admit or not admit. At that time, they're just going to explain what they did and how the family wants to proceed. And they can proceed with an attorney, or they can proceed pro se, which is without an attorney. Now, it'll be the juvenile sitting up there by themselves, and sometimes they'll look back at the parent of wondering how to proceed. And sometimes the judge will allow the parent to come sit next to them. It's overwhelming if you've never seen your juvenile arrested before. I try to warn parents because typically the probation department does talk with the family beforehand just to explain what court's going to look like. And most of the time the juvenile shows up in handcuffs or shackles. Hopefully you never have to see that, but it does happen. So that's that first court date. Any questions about that?
Well, it is alarming. I do want to say that. It feels terrible as a parent to see your child that way. And I found it very important for my child to feel there was support right there at the table with him. I always wanted a public defender, if we did not choose a private lawyer, to be representing him, just so he could feel that somebody was in fact there representing him. And then for me, I really liked to be very clearly in my parent role in the court. And so I think sitting at the table would have felt like I was trying to do dual roles, and that would not have probably felt very comfortable for me.
But you can ask the judge, if there's no one sitting there, if you can sit next to your son or your daughter, again, just to offer that support. At that time, at any detention hearing, they're going to ask about release of the juvenile. In the adult system, it's like a condition of bond. For juveniles, it's called a conditional release order. And if you're needing supports at that time, like, that juvenile doesn't come home when they're supposed to, or they've got some mental health concerns, or you're kind of seeing some things that doesn't make much sense, or maybe there's some drug or alcohol issues, you can absolutely share that with the court at that time, and they can maybe offer you some supports of that conditional release order, where they're getting drug testing, or maybe they can look at having the assessments done, or something like that at that time. They have not admitted to the case, have been found guilty. So there's some jurisdiction issues at that time. The court does not have full jurisdiction over that juvenile, so they can only offer so much, but you can surely start asking if you need that. So if they weren't arrested and they're coming to court for the first time, it's called the admit-deny hearing. Same basic setup as the arraignment. It's just they weren't arrested. Again, you're going to have a time to speak, usually to the judge, or you can even ask if they go too fast. And I'm not gonna minimize. Sometimes it just moves too quickly. Feel free to say, sir or ma'am or your honor, may I have a moment to speak? And they should offer you that time to speak. Again, you can ask at that time. They're just going to arraign the charges, explain what the juvenile has been accused of, and how do you want to proceed, and whether you're getting a public defender, or whether you're wanting your private attorney, or if they're going to move forward on their own. Folks in that courtroom is typically just those people and the prosecuting attorney and the judge. The next court date, they're going to give you a lot of court dates at that time. They're going to give you a pretrial date, and they're going to give you an evidentiary hearing date. Here's where the paperwork starts to get a little overwhelming, and why keeping some kind of a file or something can keep you up to date as to where you're supposed to be, as well as maybe having a contact person. Maybe you can even ask at court, who is my contact person if I have questions. There should be a probation officer already assigned to the case that you can contact if you have any questions.
I found, I found by regretting that having a notebook or notepad that I could write on would be a really helpful idea. I could remember hearing things, learning things, getting information that I just couldn't recall later, and it would have been helpful if I'd taken some notes as well.
So if you plead, or if your juvenile's going to plead guilty at that time, they're going to give you a pretrial. Or not a pretrial, just a sentencing date. And I'll go over kind of what to expect from that. But let's go that your juvenile is going to plead not guilty. And do not confuse that not guilty means they didn't do it forever, or you're fighting the charge. Sometimes a parent and a juvenile just need a little more time to talk with an attorney to see if there's a plea agreement or anything like that. So you want that pretrial date where you have access to that prosecuting attorney. And that's going to be the first time that you have access to that prosecuting attorney. And even in the adult system, which I sometimes work with, I'd encourage that adult to take that time and have that pretrial just to gather some more information. Don't feel like you have to move forward and your kid has to be guilty. Take that time to learn a little bit more.
I think that's really important advice, yeah.
So at the pre-trial, again, it's just going to be the attorneys probably speaking, or if you don't have an attorney, the prosecuting attorney is going to be able to come and talk with the parents of the juvenile, kind of see where things are at. You get to learn kind of what information they have and if you need more information. You may not be in front of the judge that day. You may. That's going to be up to kind of how you're proceeding. If there's been some struggles at the house and you're wanting to speak to the judge, you can ask at that time, hey, I'm hoping that maybe we can look at that conditional release agreement, modify it, change it, get rid of it. You can ask at that time, and they'll let you know if there's time in that schedule to see the judge.
Let's say that, which is true in my case, that there are some mental health concerns. Should I have already brought this up prior to this court date? My experience was I knew there were some mental health concerns, but they weren't obvious. I knew nobody else would necessarily be picking them up, and they weren't even necessarily formally diagnosed. And so, but if you feel like there is a mental health issue driving your child's behaviors, or partially driving your child's behaviors that you think need to be part of the picture and part of the awareness as you move forward through the system, if that's not being brought up to me, where should I be raising that flag?
Good question. I know that the YES program, they're going to start so that juvenile probation can actually help with that referral to parents. If you're thinking that you're wanting a little more diagnosis or some kind of testing or something like that to be able to start that process, they could do that as just a courtesy for that support. From the onset of being in court, if a parent has concerns about behavior or mental health, truly the first time you're in front of the judge, you can start offering that information. Again, there's some places that we have jurisdiction to offer that support and some places not, but that does not mean it's not valuable to know and to understand, especially if there's behavior issues at the very beginning. It's then teaches us how best support that family as well as that juvenile. Because if they do have mental health, that may absolutely look like conduct issues in the school or in the home. And we definitely want to be able to support correctly. If it's mental health, let's get them to the mental health services and be able to identify what is needed to keep them stabilized or working towards. If it's juvenile or it's like a conduct disorder, then we want to be able to put them in that way as well. So from the very first court date, or as soon as you're in the system, even if there's not if that probation officer just decide they're not arrested and you're still wanting that, any time is a great time to start offering that information, because then we can just refer, because juvenile probation officers, we're not the experts with mental health, but we can surely refer and at least get the message out there that this family is needing some supports in some way.
I think it's really important to be a really strong advocate for your child in this way, because I think it can be very easy for those issues to go undetected. And so if you're suspecting them, and really it's a great opportunity to get some testing done to try and clarify that for your own sakes and your child's sake. But as DeeDee's saying, it makes a difference in terms of where the system might go with your child based on those needs. And it was something we didn't get identified early enough for my child, and we would have just been a little better served if we had been.
The next court date, if there's no charges resolved at that pretrial, you're going to hear the evidentiary hearing, or EH. In the adult world, that's a hearing in front of your peers, a trial in front of your peers, since we don't want a classroom full of kids coming in to see if your juvenile really stole that candy bar. It's just a judge that's going to be presiding. That would be that date. Now, sometimes the charges are resolved just like that pretrial at the evidentiary hearing. So they may say we're going to the evidentiary hearing, but you may not go to trial. So that's that next date. Now, as soon as there is admittance of guilt or a finding of guilt, then you'll be given a sentencing date. Kind of went over all that. The sentencing is where a lot more, I'll let you guys give a second, that's the evidence. If you want me to stay here, just send a question or something like that, and we can keep it on this evidentiary. The sentencing is then where a whole lot more jurisdiction, and we're able to offer a lot more supports, especially for assessments and funding. Funding is going to be a big deal. That's when we're able to get involved. So there's going to be a social history interview. Am I at the right one?
No,
Okay,
it's
no,
not
no.
at this one.
Here we go.
There you go.
At the social history, there's going to be an interview that includes both the juvenile as well as the parent. And there's typically a packet that's involved, so we're gathering a whole lot of information. And this is definitely, if you have not spoken up since or until, this is your time. Because this is where probation then, my wording, but not anybody else's, this is where I put together the story of the juvenile, who they are, not just the crime, not just the police report, but who they are as a whole. Because our goal is that they are able to get through our system quickly, with as little damage as possible, get them to self-correct and move on to the way that the family was hoping. So everything you can give us at this time will be helpful. Now we can do orders for assessments at this time if you're needing that, or feel like you have not been served by other treatments. If they're already in mental health treatment, with whether it be counseling or medications, just like that, but you're wanting something done differently, you feel like you haven't been heard, this is a great time to speak up, and hopefully we can connect up and get updated information for you. And then that will help then to put together the case plan of what we're going to ask for the judge to, again, to make things right under that balanced approach.
Yeah.
And you'll be able to do it in writing. This is submitted, this report is submitted to the judge, the prosecutor, and your attorney. The parents and the juvenile have the right to read this document before it's submitted. You don't have the right to take it home, so you'll be asked to give it back. But if there's anything in that report that that you don't feel is correct or does not serve the picture that you were trying to paint for your juvenile, speak up while in court. If it hurts a juvenile probation officer's feelings, I say that's okay. This is your life, your child. State what needs to be stated, because that is going to be the best opportunity to get the needs met for you and your family. It can be overwhelming as well. I encourage parents to have stuff in writing before they come to court. So, because you'll be given opportunity in a sentencing to speak on behalf or what support you need. Have it written down, because even although I've done this for 16 years, sometimes I get nervous in front of the court and don't speak everything that I want to say. So I encourage families to do that. I'm going to quickly go over just kind of what some probation is, because there's some things a little further in the case management plan that also gives families opportunity to speak on behalf of their kid in regards to continued problems with behavior and mental health. So I just quickly want to explain informal adjustment probation. In the adult world, that's called a withheld judgment. Basically, if the juvenile completes probation appropriate or without any incident, that case can be dismissed. And then they can look at expungement. Dismissed is different than expungement. That means that when the juvenile still has a record, once that petition is done, that record begins, probation continues that record, whether it's unsupervised or supervised probation. The informal adjustment allows for that dismissal. And I would encourage parents that once that case is closed, to look back at, it's called I-courts now, to make sure that it shows dismissed. And depending on the misdemeanor to felony, then you can go back after a year or 5 years, I think is felony, maybe 3, and have it expunged off the record. And then there's formal probation, which means they don't have the opportunity for it to be dismissed. You can still have it expunged. Okay.
Well, I was just going to ask you why do families, both the youth and the parents, want to keep track of that and go through the expungement process?
Good question. Just because it says dismissed on the record does not take away possibilities for someone's future. As the military can be sometimes very picky about who they take, or open, they could take someone without a record over someone with a dismissal. So I encourage all families, and I believe most judges too, to go back and have that expungement, to mark it on your calendar and go back. And I don't know of any that have been denied, because usually if the parent's willing to take the juvenile back to court and say, look at what my son or daughter's done, or they're adults and they go back and say, look what I've done, the courts want them to be able to have a future and to have more freedoms with that future. So I'm going to quickly talk about the risk assessment to assist in supervision. We don't just willy-nilly decide how we're going to supervise a kid. There is a risk assessment that is connected with the social history that probation officers do. I encourage you to ask about what that looks like. It goes over like 7 domains. That includes criminal history, substance abuse, family, personality. That's a lot of the mental health stuff. Also attitudes, friends who they're hanging out with, that kind of stuff. And if they assess at a certain level, then that decides how they're going to be supervised and what that case management will look like. We do home visits, school visits, office visits, and I also want to talk about the Fourth Amendment waiver. The Fourth Amendment waiver, we usually explain to the juveniles what that means. It's that protection for unlawful search and seizure. That can be waived partially or fully. Partially meaning it's usually just for drug testing, and then fully would be for full search and seizure. And it's typically of the juvenile space, not mom and dad's, grandma, grandpa's, anybody else's space. It's like their bedroom, their car, their locker, stuff like that. Do you have questions about that? If your juvenile has that, please ask for that clarification. At the same time? I don't know if we did at the same time. So this is what I wanted to make sure I spent some time going over. There are several times throughout probationary period. It can start as soon as they're admitted, they admit their crime or found guilty of the crime. These things can open up for you. The worst being the last, and I'll go over that a little bit. But 20-511A screening team. That is under the Juvenile Corrections Act. It's a code. It's a code that the judge can order a children's mental health assessment and screening team. And they'll do the assessment with the family and with the juvenile, and then they are to bring everyone together, whether it be juvenile probation, the parent, the school, any counselors, all at one table to make a plan of action of what to do with the juvenile. And this is mostly for those with the mental health issues. I find them very helpful if we've got any kind of a concern for a juvenile, because again, I'm not an expert, but I get to get all the experts at the table. And they don't leave that table without a plan, because the judge wants that plan to make sense.
That's not something I knew about here in Idaho. I think we had an assessment ordered, but we never got that team approach. Where I encountered that team approach was actually when we were in the juvenile justice system in Wyoming, so I can speak to the benefits of that approach quite a bit. Having the probation officer, a mental health professional who had been involved with my son, teachers, all at the table with us, we really did feel like we had this collaborative effort where we were trying to set my child up for success. It felt like it wasn't all on us as parents, which was nice, but it also felt like we were a really important cog in the wheel. And so while I didn't experience it here in Idaho, the fact that it is here makes sure that you are able to experience that. We had a screening done, but without that follow-up piece, I felt like it's just we missed an important piece there somehow. And of course, this was several years ago. So I think anytime you can have multiple disciplines coming together, really looking at your child very holistically, it's to your family's and your child's advantage.
Yes, and so that you understand the difference, the judge can order a children's mental health assessment,
I think that's what we
but
have.
that's different than the 20-511A screening team, because it's the assessment with the plan when everyone meets.
Yeah, that's a nice piece, and I would recommend people advocating for that piece.
Yep. There are some jurisdictional issues, meaning there are times when that can and cannot be ordered. Sometimes the judge will say, I'm going to close it, or it's closed. I'm forgetting the word, sealed. It can be sealed to the court, but then just present the recommendations. There's lots of things you may hear, but surely ask about that if you're wanting more supports. It also helps with funding, because this helps children's mental health with their funding. It also encourages that family engagement piece, because they can't move forward without that family engagement. So it offers a lot of supports in that manner.
I think having the school at that table is just particularly wonderful, because for them to really be learning more about your child and your child's challenges, I think they can just bring better services and more appropriate expectations to that child in school where they spend a lot of their time.
And they may not think about inviting the school, so feel free to say, you know what, the school's been working, we have an IEP. Because I think for all of us, we don't want to reinvent a wheel that's already been done. If we can all get at the table, we can look at all the years that this juvenile has been getting the supports that have worked, not worked, that kind of worked, but maybe we want to tweak it a little bit all at once so that we're not wasting further time getting the juvenile the supports that they need. The YES program, also the Youth Empowerment Services, can also be utilized at any time during this process because juvenile probation can just refer it to Liberty, as well as kind of like the same ideas that the team of the screening team works the same way.
Can you share who Liberty is for parents who may not know?
Yeah, and I'm still learning this process as well. I just had a juvenile on my caseload go through this. Liberty is the beginning. It is the referral. We send the referral to Liberty, and they do the quick assessment to see where the juvenile goes next for children's mental health or any kind of mental health services, and seeing if they qualify at that 300% over poverty, and if they qualify for that SED. And Carol, you can pop back in if I'm not explaining that correctly, but that just begins that process for those services. So that can happen at any time. Right now it's going through just the children's mental health because I think they're making sure that it's running smoothly. So do ask those questions of how to get involved in that. They have to have that ED and that 300% above poverty level. Mm-hmm. The juvenile that I just had go through it, the issue was Medicaid ran out. Mom and dad started making just a little too much money to be able to be served by Medicaid. And juvenile justice funding was able to support a little bit of that until the worker, the children's mental health worker, actually put them through the YES program to get that Medicaid back in place because of that 300% above poverty level. It's a different kind of qualification, and he had that ED qualification. So juvenile justice money was able to support, and I don't have it on here, but I'll explain what that means. If a juvenile is looking at being committed to the Department of Juvenile Corrections, which is kind of jumping to the last bullet here, the juvenile justice program in Idaho will do whatever they can to keep the juvenile in the community and in the home, because that truly is the best place for them to be if they're going to self-correct. And so there is funding support to access treatment, services, transportation, all those things, in hopes that they'll self-correct while they're here. So you can always ask that probation officer if you're having any kind of funding issues and they're looking at that DJC or Department of Juvenile Corrections staffing, if this funding support is available. They'll typically talk about it at the staffing, which I'll go over a little more here in just a second, because those are overwhelming too. So CMDT, this is something also that you can request as well as probation request to have. Same idea as the screening team. It's a community multiple disciplinary team where you collect all the pieces and parts together of all the people that are involved in this juvenile's life to put together a plan. So, I use them a lot, mostly because it takes a village sometimes to help correct and stabilize a juvenile. And that can happen anytime in the process. You do not need an order, you don't need anything. Just if you're needing everyone to get to the table, this is a good way to do it. A community multiple disciplinary team. So the DJC staffing, just to separate out, DJC or Department of Juvenile Corrections or the Idaho Department of Juvenile Corrections is state. It's not county. So if a juvenile we've exhausted, and there's criteria that juveniles would have to meet, it's not like they just go because. They have to fit criteria. And there has to be a staffing with all the same people that I've kind of talked about at that staffing to see if indeed they qualify. And if they don't qualify, then they revert back to then what plan. All the folks that are at the table, what plan can we put in place that the community may be able to support this family and this juvenile for success instead of Department of Juvenile Corrections. Communities are different rule, different areas, that kind of stuff, and how they look at that. But I think for the most part, they practice that. They want them to remain in the community first because it costs a whole lot more money for them to be in the state's custody than it is to be out in the community.
And some of that, I think, just ends up being potluck, what community you're in and what kinds of resources
Indeed.
you have.
And now there's some states' custody programs that merge mental health with thinking errors or with substance abuse or with sexual offending behavior, but they do not have any facility that is just for mental health issues. So even though I think the services they've provided many of my mental health issues with kids, they've done a fantastic service, but in others, still just in the community, they may miss stuff.
Yeah.
So. I think that's it.
You're there. Nope, I think you went back.
Okay, I'll let you press the button. So I kind of go on in this next slide a little more. Yep, Juvenile Justice, Department of Juvenile Corrections, and the criteria. The legislature changed that criteria a little bit, which makes it a whole lot more gray in general. Before it was much more specific, but again, they still look at what can be the least expensive and leaving them in the community. I also wanted to point out if they are committed for any reason to the department, then juvenile probation takes a backseat role and another person then comes in for case planning. So even though juvenile probation has come a long way with the youth and the family, then once they're committed, then somebody else gets involved. Again, the role of the parent should not change. You are still a partner and you still have a lot to say. Because again, now you've seen what's changed, what hasn't changed, what works, what doesn't work. And even though they're going to do a whole lot of further testing, they're in state's custody, there could be some things you get, like, that we did that and it didn't work, or, we've wanted to try that and can we do that? But the JSC is a juvenile service coordinator, and then they take over as the case manager while they're in state's custody. And everybody else is then just a partner. And while they're in state's custody, family involvement and engagement becomes trickier, because now there's only 5 facilities in the state that your juvenile could go. There's a couple outside the state that they could also go, is then being present. How do we get mom and dad, grandma, grandpa, everybody there to touch the kid, be with the kid, let them know they are loved? I got a testimony from a juvenile who had been in custody, and the fact that they could not touch their parent or that their parent did not call, it became a conversation in their pods. Did you get a call from your parent today? Did you get a letter from your parent today? We did. And it makes them feel less and less involved in the rest of the life that feels like they left them. So being in state's custody more than ever, or in detention, having that contact with the juvenile is so important. Even though you're frustrated, even though you're angry, you still love your juvenile. No one questions that. But they need to know that more than ever when they're in their worst of places.
Well, I totally agree with that. And I saw the huge benefit our close support was for my child as we went through this a few different times, actually. What I would say is for some families, this is so much harder than others, and that's the piece that is not fair, but depending on where they are and what your resources are, and both time resources and financial resources to get to where your child is, it can be a huge strain on a family. And so I would say just finding out what resources can help you with that piece, asking the people you're working with in the system, show your interest in trying to be there, but speak to the barriers and obstacles that you have in getting there, and see if you can get some help in managing those obstacles for yourself.
And those obstacles are such simple things sometimes. I know I've worked with families with the juvenile just needs an alarm clock, and we'll get them the alarm clock because mom or dad or everybody has to be up early and off to work, or the families need the juvenile home to offer babysitting after school, or transportation. A lot of little obstacles that can hinder a family being involved. Share that. It may be embarrassing, it may be uncomfortable, but this system is here to meet you where you are, because again, we don't want the juvenile back in our system if we can stand it, and work whatever we can to have that not occur. So your needs may be simple, but state them. We don't want you to lose your job. We don't want you to not be able to pay your power bill. we don't want to overwhelm a family, especially if you have several kids and the court is taking a whole lot of time just for one. Process that. If you don't believe that you're being heard, I will encourage you to go to the next level of the supervisor and see if you can't get a probation officer that's going to listen. Because some of us do better than others for sure, just as some families do better than others for sure. But that doesn't mean you're wrong or you're bad or you're not doing a good job. It's just it's hard to communicate in a system where someone feels powerless. Mm-hmm. And that's kind of where we're going to end all of this today, is to remind you, you have a voice. You may have to process in your own mind where that voice is to be heard. I remember, again, being new in the system, just as a probation officer, that it was overwhelming. Sometimes knowing what to say, when to say it, how to say it. I got better at writing everything down, so as soon as I felt I had opportunity, or I just asked, may I interject, or may I add? And sometimes I would even, the parent may be too scared to say, and so I will read the parent's statement. And then that's able to get them kind of talking a little bit.
Yeah.
But we can't do this without you. You've known your son and daughters a whole lot longer, both good and bad. And for the most part, we respect. There's a different, I'm sure you guys all know, there's a different sound between offering supports for your kid and demanding. There's some things that when a parent demands, in that we can still take and work with, but other things, there's also just jurisdiction issues that we can't do. So ask your questions. Ask them again if you don't think we're being heard or you're being heard, and be able to go up that chain of command and ask the questions.
Yeah, I concur on that, and I think this journey is not without a lot of angst for families, and the added angst of your child frequently, and trying to deal with your own feelings and your child's feelings, and finding the supports that you need is really important, because this is a time when it's very easy to isolate yourself and your family. I've experienced that. You just feel like I'm in a place that nobody I normally interact with knows anything about. They're not dealing with this type of family situation, and their kids are on a very different trajectory. And it can feel pretty miserable and alone. And I think it's really important to realize that you are not alone at all. You just may not know other people on this journey, but do work with the people in the system to ask for the resources that you need to help you through this.
And if you don't understand the language of our court system, ask. We surely get just kind of going, especially if I'm in my third or fourth sentencing of the day, you just kind of get moving. Sometimes we need to remind to stop and to talk with the family. If there's language issues, if there's what does this mean on this statement? Because sometimes they use a lot of acronyms in our court system. Ask all those questions. We should take our time to explain it to families. We just sometimes may forget. So I think I ended my slide with that probation officers are people too, but ask. And if I know that if frustrated you need something, we may say, hey, how about we talk about this more tomorrow, or can we when I have more time? Or even you can ask, hey, when you have more time, can I come by your office and ask? We will offer that. I have yet to meet a probation officer that hasn't offered that. So ask for it.
My experience in the system was, even though we didn't always have everything we wanted, and we did feel sometimes somewhat misunderstood, I think the reality of our experience was that we were working with some very well-intentioned people most of the time, and people who wanted good outcomes for our child. And so I think if you can just look through that lens of finding the people who really do care to make the journey easier for you and show them how it could be easier for you, the communication is the piece that it's really incumbent on us as families to speak up for what we feel we need and to advocate for our child and with their needs.
And I offer that same support. All that is so, so important. I have yet to meet a family that isn't fantastic to work with, even though there's frustrations and roadblocks in communication. I cannot say in all of my years that I've met a single family that did not care for their juvenile. It's just that communication piece and being able to take that time to hear what is needed. or even educate each other on what is available. I think we all wonder sometimes what really is left, what's available to this juvenile for their success, and that takes some time to find those resources to support. I think we both thank you very much for your time today.
Absolutely.
And if you have questions, both juvenile justice or even from a parent perspective, just email the Federation of Families, and then Carol can probably follow up with us. It makes it easier also if you're probably just want to be anonymous and you have a very tough question to ask, maybe an easy way to do it.
Great. A lot of information and a lot of really important information. So you kind of already covered this, but I'm going to ask you again. So if you just had like 2 or 3 points, Ruth, that you would want like probation, juvenile justice people to know about parent-family perspective, are there things that you would throw out to them? And to give you a second, I'm going to also go back to you. Like, what 2 or 3 things would you want parents to know, just like the little nuggets? And I know you've already covered them because you hit on some really important ones, but which ones kind of like bubble to the top if you're like, okay, I just want you to know like these 2 or 3 things? Anything
I think
really
from the
jump up?
parent perspective, what jumps out at me is that parents are frequently on a whole new playing ground all of a sudden when their child gets involved in the juvenile justice system. As I said earlier, not anywhere we envisioned our lives together were going. And so regardless of the savviness of the parent in trying to wade through that, we're still going to be functioning off of a fairly emotional place. We're scared for our child. We feel, I think many of us frequently feel like we failed or our child wouldn't be there. People that we're working with in the system understand that we're feeling a sense of failure even being there, and helping to calm that feeling for us and work with us in a place where that can be allayed for us a little bit, I think is really important. I'll think of what else while you.
I think for me, just being a probation officer in this system, I don't know unless you tell me. If I don't know, then I'm just going to do. And so I know that I do the best I can with the information that I'm given. And so if the family is feeling that the information is wrong, they're the only one that's going to educate me, or the school, or somebody else. So I think that's all that I can offer, and I'll keep it simple that way, is we do the best we can with the information that we have. So I encourage always the families to be able to speak up on behalf of their juveniles.
Okay, something funky is going on with audio, so if you all are getting it also, I apologize. I know Mike is working on it. So just to kind of close up, one thing I wanted to, because Dee hit this several times in terms of the YES program, which is the Idaho's new children's mental health system of care, and YES stands for the Youth Empowerment Services. And is a lot of information online. If you go to yes.idaho.gov, you've got more information probably than you know what to do with, but it's a really great place to start to understand, who is eligible for it, what are the steps involved, what are the services, what's rolling out, kind of what the time frames are, and things like that. Juvenile justice from the state level, Idaho Department of Juvenile Corrections has been at the table from the very beginning of the development of the YES project. So there's a lot of investment to ensure that kids are getting served on the children's mental health side, as opposed to kids with mental health issues having to be served through the juvenile justice system. We recognize, the state does recognize, a lot of times kids with pretty significant mental health needs were ending up going through the courts to be able to access services, and they are working hard to turn that back around. So those kids are getting served in the communities where they needed initially, and hopefully not even getting involved in the justice system, that the courts aren't even going to see them. So recognize a lot of credit to our juvenile justice system, that they are definitely definitely players in this. From the state level, it kind of like is trickling down to the county levels, and from county to county, it's pretty different as far as, you know, what they understand at this point in time, but eventually it's really going to roll out statewide and kind of be, instead of so siloed, kind of more integrated with all the systems working together, and that's what everybody's working for. And also to understand, like for the families who there's an increased level to be able to access Medicaid, so it's up to 300% of the poverty level, and it is worth definitely going to Liberty Health to get the cancer assessment done, also to do the evaluation to see if you qualify for Medicaid services. Even if you do not qualify for Medicaid, the state still has plans, because the YES Project is not just for kids that are on Medicaid. It is for every child in the state who qualifies as having a serious emotional disturbance. So it's worth finding out, because definitely if your child is Medicaid eligible, it makes it a little easier, but there are services for every kid, no matter Medicaid or non-Medicaid.
And these are huge changes that we've seen in our state just since my oldest is 21 now, and we entered into the system when he was about 13, and then exited when he was just before he turned 18, fortunately. And the change that we've seen since he left the system and while he was in it, we have a lot of positive momentum going in Idaho.
And I was really surprised how fast the services got in place with my juvenile that just went through the YES. I think he was connected right back up within 3 weeks. Ours covered just about a week or two of services, and then they even backlogged. So even though Medicaid started, say, on a Thursday, they paid for the previous Monday through Friday plus that week of services. It was fantastic.
Mm-hmm. So good things are coming. So ladies, thank you very much for your time. And I know there is in the future, there's even more juvenile justice to go a little bit deeper. So I will hope that you'll come back and join us at a later date. And Ruth, as a parent, we always love having your perspective and knowledge that you bring to the table. So we're in April now, so May, we have another similar format coming up. Title for May, Child Welfare Received a Report About My Family, What Now? So this could be some really good information. I know for families who have kids with really complex mental health needs, it's not unusual that CPS gets involved and has stepped in because services don't exist. Families are doing the best they can, but problems come up, and CPS sometimes gets involved. So this is a really good opportunity to hear from CPS just in terms of how that whole system works, but also hear from a family or a parent who has been through it and has worked closely with CPS trying to make sure that the best outcomes occur after their engagement. So join us for that. It is May 11th on a Friday afternoon or Friday morning. That'll start at 10 o'clock, and we'll be pushing that information out shortly. So again, I hope you all had something here that was helpful to you, and look forward to seeing you all next month. Ladies, thank you very much. I appreciate your being here.
Thank you.
You bet.
Thank you.